Good afternoon, everyone. We're going to get started. So welcome back to our third, I think, of our speaker series. And today, I'm particularly excited that we have Ian here, who we've been mentioning every one of our last sessions. But I'll turn it over to you right away.
Well, thanks, Lisa, and welcome everyone to another installment in the Vale Center on Sustainable International Investment. Got to get that right. I think in past years I've garbled that a bit. So this is our annual speaker series, and Crowland Mooring is very happy to once again be a co-sponsor along with our friends at Curtis Millay and the Center here on International Arbitration. So thanks to our sponsors. Today we have a very exciting speaker. Not that all of our speakers aren't exciting, but I think today's speaker is an individual who's played a leading role in the international arbitration community. And in the sphere of international investment arbitration, international commercial arbitration has had a great influence in its development, in its procedure, and in contributing to many of the arbitrators who hear investor-state arbitrations and decide, some would argue, a great deal of the development of the law in this area. So it's a real pleasure to have someone of the standing of John Beechey, who's been a stalwart individual in so many international arbitration organizations, including the London Court of International Arbitration, the American Arbitration Association, and currently he's fulfilling the role of chairman of the International Chamber of Commerce International Court of Arbitration. So I'd like to thank John for coming today and give you a warm welcome from Columbia Law School.
Thank you. Three preliminaries, if I may. The first is that, courtesy of my wife, I seem to have re-exported to New York the cold that she collected here about 3 weeks ago. So if I sputter a little bit, I'm afraid it's not actually typical of my normal delivery, which is generally accused of being too fast to be followed, but there's got to be some protection somewhere. The other point is that I've been reading all sorts of things about needing to make sure that my camera on my laptop is turned off and all the rest of it. I find here I don't have to worry about that. You've hidden it in the corner, but it still seems to be operating. So I hope that whoever's at the other end of the camera isn't too disappointed. The third is that despite Ian's comments at the start, I think it's fair to say that what you might get from me is, if not a jaundiced view about what is going on, then at least a realistic view. And it will be borne out with a degree of anecdotal evidence about which you can form your own views. But let's break this down. The title is a mouthful. It's Commercial Arbitral Institutions and Commercial Arbitrators. And pausing there, of course, I have to disclose an interest in both. I do sit as a commercial arbitrator. I also serve as an investment arbitration arbitrator, and I'm presently head of a commercial arbitral institution. So when I ask the question what role they play in investor-state treaty development and investor-state arbitration, then I have a certain interest to advance. So let's look first at this question of investor-state treaty development. And the brutal answer is that traditionally there has been little, if any, interaction between government agencies tasked with the drafting of investor-state treaties, the commercial arbitral institutions, and arbitration practitioners. And you'll forgive me for saying this in hallowed academic surroundings, but states typically have chosen to rely upon the advice of their own legal services and that of academics. And the basis upon which a particular academic has been chosen to advise the policymakers is typically shrouded in secrecy, and there is, of course, no question whatever of accountability. Consultation with the arbitral institutions, much less the wider arbitration community, has been rare. In the ICC's own experience, based upon its attempts to obtain a hearing in the context of such consultation, has been disappointing. Now let me put that in concrete terms. Last June, an ICC delegation travelled to Brussels to talk to the team within the Directorate General Trade tasked with the preparation of the new intra-EU BIT. And it became apparent very quickly, to the extent that there had been any consultation beyond the law officers of the member states, or indeed all of them, it had been restricted to a very small number of academics, mostly German. And we pointed out that the ICC Court had had some 90 years of experience of international disputes resolution, and that long before the Washington Convention entered into force on 14 October 1966, the ICC Court, along with the Stockholm Chamber, had been one of the very few institutions designated to administer arbitrations between states and private parties. We pointed out too that quite apart from the institutional knowledge vested in the ICC Court, a very large constituency of arbitration specialists who in recent years have acquired a wealth of experience in disputes between state parties and private entities, and whose views might have a bearing upon the new proposed BIT, were simply being overlooked. Well, we were listened to politely. We were even given a cup of Belgian coffee and a chocolate, and that's as far as it went. And we've since been told unofficially that DGT is concerned to avoid any suggestion that it's been subjected to lobbying by an organisation assumed wrongly to be closely aligned with the interests of international business community, and thereby lay itself open to criticism by the European Parliament. Well, I suppose it takes a dog to recognise one, but the idea of the European Parliament complaining to anyone else about lobbying comes a bit rich. Now, one of the few fora in which it's possible for the arbitral institutions to have some interaction with governments in the context of the development of policy, rules affecting international arbitration as well as the development of arbitration rules, it is the UNCITRAL Working Group. And a number of arbitral bodies, including the ICC, the AAA, the LCIA, and a number of others, have accredited observer status to the working group. And that means that they can participate in, and indeed they have participated, in the discussions and deliberations of the delegates of the members of the working group, which comprise states which are members of the United Nations. Now this is an effective, if somewhat cumbersome forum. It is designed by committee writ large, and it's fair to say that if you attend one of these sessions, it is principally a day of boredom, watching varying states put up their paddles, being recognised by the chair, being allowed to speak, sometimes informatively, sometimes not at all, and then the real work gets done in the corridors over the coffee breaks. But it was ever thus at the United Nations, but at least it works. And on numerous occasions, proposals made by observers have been adopted by the working group, and it has to be said that among the most effective of the national delegations are those which include recognised arbitration practitioners. But inevitably, the ability to engage with states and to influence policy in the broadest sense is delineated by the subject matter before the working group. Now true, the working group was the vehicle for the revision of the model law, but otherwise its involvement in issues going to the formulation of principal treaty terms has been tangential. The most recent deliberations of the group considered the contentious issue of transparency in arbitrations involving states. But those negotiations once again demonstrated how effective a contribution the arbitral institutions and experienced practitioners can make. Those discussions were at breaking point, complete and absolute breaking point, until a couple of small groups got together and came up with a proposal that the members as a whole were able to accept. But the critical point that emerged from all of that was that at the end of this debate, it became clear that to the extent there was going to be an argument about privilege over any documents, the last word didn't rest with the states, it rested with the arbitral tribunals. And that was a matter that took days to sort out. So, the short answer to the first part of the question is that states demonstrate little appetite to consult the commercial arbitral institutions, much less commercial arbitrators, and I think that's regrettable. The more so because the basis for not doing so appears in broad terms to be based upon a misconception as to the role and standing of commercial arbitral institutions, and by association the arbitrators who serve on their tribunals. And that's to say, according to the states, they are by dint of their history and user base irrefutably and inherently pro-business and anti-state. And by extension, it seems arbitration practitioners in private practice or serving as in-house counsel will inevitably be aligned with the interests of the private sector and hence putative investors. Well, there's always a grain of truth in these things, but overall it must be said that is a complete fallacy. While I can no longer speak for any institution other than the ICC International Court of Arbitration, I can state unequivocally that the ICC Court is fiercely independent of the rest of ICC. It has no involvement whatever in ICC policy formulation or in the engagement of ICC as the voice of business, as it's called, with governments. The primary task of the ICC Court is to administer arbitration conducted under its rules, to take all possible steps to ensure that any resulting award will be enforceable, and to uphold the integrity of the arbitral process. I'll repeat that, to uphold the integrity of the arbitral process. That's what it's about. And part and parcel of that latter task is to ensure that all parties are treated fairly and with equality, whatever their provenance or standing. And in any event, is it not better to formulate policy on the basis of an informed understanding of the preoccupations of the institutions and users who have to live with the product of the policymakers' labours, even if that results in having to deal with issues and concepts that it might be more convenient to overlook? The deliberations of the Antitrust Working Group haven't suffered at all by reason of private interest involvement. Rather, I would suggest the contrary. And what is utterly frustrating from the point of view of the institutions with which I'm familiar, and certainly on the part of many practitioners, what frustrates them is that one simply cannot get past this perception. However much one tries, the walls are still to be breached. Small progress made, but we've a long way to go. So despite that failure really to engage with states at the level of developing policy, do we still have a role as institutions or commercial arbitrators to play in investor-state arbitration? And the answer is absolutely right, we do. Now, states might be reluctant interlocutors with the arbitration institutions and arbitrators, but the plain fact is that not every dispute between a state and an investor is an investment treaty arbitration, whether under the ICSID rules themselves or administered by ICSID under the additional facility rules, or subject to special rules such as the NAFTA rules or those of the Energy Charter Treaty. Brazil, for example, has no BITs at all. It's never signed up to the Washington Convention. Canada only very recently signed up to ICSID. And in the meantime, going the other way, Bolivia, Ecuador and Venezuela denounced the ICSID Convention in 2007, 2009 and 2012 respectively. I have a very interesting case running at the moment where at one point it looked as though there might be a jurisdictional issue raised on the basis that the arbitration was proper at the time it was commenced, but any attempt to bring in a new claim now might fall foul of the fact that the time limit had ticked away under the denunciation and therefore that claim could not be introduced. Sadly, in a sense, we're not going to be allowed to deal with that. But other states which enter into international agreements have, for a variety of reasons, not wished to sign up to the Washington Convention, notably Iran. But states do enter into investment contracts, and they may provide that an investment made pursuant to the investment law of that state be referred to arbitration. So if for any reason ICSID is unavailable and the parties require an administered arbitration, they have to look elsewhere. And it's instructive to review some of the older BITs which predate the foundation of ICSID altogether, or which were prepared at a time when a particular state was not yet a contracting state, albeit that it intended to become one. Many of these older BITs will stipulate ICC or the Stockholm Chamber, while many of the latter have what may be described as a cascade arbitration clause. Typically, it will provide for a referral to ICSID if by the time the dispute arises the state concerned has ratified the convention, failing which there will be recourse to, say, arbitration under the ICC rules. And it was very much with its past preeminence in the field of investor-state disputes, and the fact that every year some 10% of the ICC court's caseload involves a state or a state entity. With that in mind, it was that the ICC determined to have regard to the particular requirements of states and state parties when it set about the revision of its rules, resulting in the new rules which came into effect on 1 January 2012. Now, working in parallel with the task force charged with the rules revision exercise itself, the ICC Commission set up a task force on arbitration involving states and state parties under the joint chairmanship of a practitioner and academic, Eduardo Silva Romero, based in Paris, and Peter Goldsmith, Lord Goldsmith QC, formerly the Attorney General of the UK government and now a practitioner. Now, its membership comprised representatives of government legal services, and public international law specialists, both practitioner and academic. And many of its recommendations were incorporated into the 2012 rules. But we kept apart the final report because it was intended to explain notably to states how ICC arbitration worked in relation to disputes with states and state entities, and that was published in September 2012 as a standalone document. And thereby hangs a bit of a tale, because at the time the report was produced, the Saudi Arabian government had recognized, in effect, that it was simply not possible to get investors to undertake arbitrations in Saudi Arabia under Saudi Arabian law. There were too many issues of uncertainty, too many concerns about the way in which the process would be run. And at that time, they were looking to set up a sort of standalone, free-floating arbitration institution, they thought in London, which would operate under some sort of international aegis. And they were looking, among other things, at what rules to adopt. So, being ever the opportunistic businessman, I made sure that we invited the Saudi Arabian government to a conference in London to present this report. It's indicative of the way things move that the Saudis responded by return and sent a delegate. Letters to various departments of the UK government and to the French government went absolutely unanswered. Nobody was remotely interested. So from the legal advisor to the Foreign and Commonwealth Office down to the Prime Minister's office, nothing was to be done about it. And eventually the project, as it happens, folded, but our rules continue to stay in place. Part of the problem was that the British government is concerned to be seen to support what arbitral institutions stand in London. They have, interestingly, this concept that the ICC is therefore a French-based Paris organisation, and so one sees how perceptions begin to play, and policy, clear, rational decision-making just doesn't take place. It's all done on the basis of what they anticipate the answers to be before they've even asked the questions. But in any event, among the recommendations that the Silva-Romero-Goldsmith report came up with, and which we adopted in the rules, and which are designed precisely to meet the sort of requirements that states find important, were suggested wording of a provision in a BIT, a multilateral investment treaty, an investment chapter in a free trade agreement, or a domestic investment law affording an investor the right to have recourse to ICC arbitration. We changed the rules so that they no longer refer merely to business disputes. And since 85% of cases involving a state and 86% of cases involving a state entity are always referred to three-member tribunals, there was a recommendation that in such cases an express provision to that effect be added to the standard ICC arbitration clause. In terms of reaching agreement as to who should preside over such a tribunal, we've extended the normal 30 days to 60. And the provision for any appointments of a presiding arbitrator required in default of party agreement is such that it can only now be made by direct appointment of the court. Why is that? Because we did not want any suggestion that a nomination by an ICC national committee might have been tainted by some lack of neutrality on the part of the national committee concerned, because its membership comprised leading business associations and companies in the country in question. States required that we made arbitrators expressly confirm their impartiality as well as their independence. We've done that. We've made it clear that where necessary, one can write out contractual provisions. If it's a treaty dispute, there won't be any contractual provisions, and trade usages which otherwise might apply, again, may not necessarily be applicable. We've allowed an opt-out for states from the application of the emergency arbitrator rules, and then the interesting bit, we provided for express agreement to make public the award, the proceedings or the submissions of the parties, and in particular for the communication of reasons for decisions of the court, which are normally entirely private, in respect of objections to or non-confirmations of the appointment of an arbitrator, and indeed challenges to and the replacement of an arbitrator. So that's an example of a commercial arbitral institution trying to meet the states at least halfway. Now, what about commercial arbitrators? I think it's fair to say they have very little, if any, direct or immediate impact upon the development of the treaties themselves. But as Ian's already said, they play a major role in the development of investment law. And the numbers alone tell a convincing tale. If you look at the ICSID and the PCAA websites, you'll see that commercial arbitrators sit on nearly 2/3 of all investment arbitrations, 75% of which are based on an investment treaty. And that's to say nothing of the commercial arbitrators who find themselves adjudicating state-private party contract disputes or disputes referred to arbitration under a domestic investment law. Why do they seem to be quite good at this sort of thing? Well, they've got a good grasp of commercial transactions. Their experience tells them to go about valuations in a sensible way. They're good at complex fact-finding. They're good at case management. And they're good at setting out reasons. And this is not a new phenomenon. If you go right back to the very early oil nationalisation cases, you'll see that it's people like Lagergren, people like retired English High Court judges who are serving as sole arbitrators, heaven help us, in massive disputes. And they are not, in any sense, known for their expertise in public international law. And in the context of investment treaty arbitration, it's been suggested too that they play a crucial role, you heard this from Ian, a crucial role in the development of the law through case law. Now, that's a statement which is couched in quite deliberately unqualified and provocative terms for reasons upon which I'll elaborate. But it's a fair representation of a widely held view. And let's see how the point's been articulated. One example, a case called Saipem in Bangladesh. The tribunal went so far as to say this: we consider, and it goes on, it is not that it is not bound by previous decisions. That's the SOP. At the same time, it is of the opinion that it must pay due consideration to earlier decisions of international tribunals. It believes that subject to compelling contrary grounds, it has a duty to adopt solutions established in a series of consistent cases. It also believes that subject to the specifics of the given treaty, under the circumstances of the actual case, it has a duty, there's that word again, it has a duty to seek to contribute to the harmonious development of investment law, and thereby meet the legitimate expectations of the community of states and investors towards certainty of the rule of law. And one can see how beguilingly attractive that might be in the context of expropriation claims or determinations of fair and equitable treatment and the like. But that was a pretty extreme statement, a duty. And other tribunals have been less brave. The Noble Ecuador case, I don't mean that, I mean Noble Energy case, took a slightly sort of back step from that. They came to exactly the same conclusion, talking about expectations of community of states and investors towards certainty of the rule of law, but they went so far as to say that we should adopt solutions, no question of a duty. We should seek to foster harmonious development, again, no question of a duty. And then you get to Wintershall, and you find that it's a matter of these decisions warranting examination. So you've got a gamut. And that leads me into something rather more academic than I have had time to do today, and indeed repays careful attention, and that's a lecture by Professor Michael Reisman, the 2012 Freshfields Arbitration Lecture, which if you haven't read, it's worth reading. It's at Arbitration International, Volume 29, Number 2 for 2013, and it's called Case-Specific Mandates versus Systemic Implications. How should investment tribunals decide? And it's an important lecture because he considers the issues that arise out of a decision in the NAFTA case, Glansgold in the United States, where it may be said that having gone from what ultimately Professor Reisman thinks is the right approach, which is case-specific, he's identified what he describes as, well, I've described as a degree of mission creep. He's a bit more polite than that. And he talks about the way in which the tribunal seeks to make its decision an indication of the fact that it has had an awareness of the larger context, whatever that might be. So out of Glansgold comes this very interesting series of arguments by Reisman, in which he draws a clear distinction between the role of the lawmaker, who must identify and take account of the systemic implications of alternative possible legal arrangements, and that of an international investment arbitral tribunal, which is authorized to act only as a law applier. And indeed, even within the lawmaker's ambit, there is a huge difference. If you consider, for example, two states negotiating a BIT, well, each state has a very clear remit. It's looking after its own interests and those of its outward investors, and it wants to secure the best deal for them. And that, of course, is what is going on the other side of the table. It's a balance of specific special interests, and the interests of the investment treaty system as a whole are probably coming a very distant third. But if you compare that with working groups tasked with arriving at multilateral agreements, OECD, WTO, UNCTAD, their remit is very different because it's coloured by the fact that you need a degree of consensus. You've got to get a whole series of interests to come roughly together. And you've really got to come up with something which is going to find credibility with a large number of states and to provide a real degree of cohesion so far as they're all concerned. So even within the question of the lawmaker's remit, there are some questions to ask. So in the context of the law applier, how far can you go beyond a particular case? Well, certainly, says Reisman, you've got to give thoughtful consideration of prior, relevant, and then the important point, on-point decisions. That's not to be precluded. And the arbitrated decision maker in such circumstances is, however, going to have to bring that reading to bear on the case in front of him or her. What are the objects and the purposes of this particular VIT or investment chapter in question? And to the extent they need to be interpreted, then he's very firm, you come back to the canon of treaty interpretation. Now, what seems to me to be interesting in all of this, let's go back a few minutes, is you'll remember my referring to people who've moved from commercial arbitration to investment arbitration. Well, there is inherent in all of that an ability to move successfully from the adjudication of purely commercial disputes to a dispute engaging the interests of the state in an investment dispute. And that requires a certain flexibility of mindset. And that, it seems, has been lost on those who are wary of engaging such practitioners in policy development. Now, my experience is by no means as great as that of many of my colleagues, but I would suggest that an arbitrator from a predominantly commercial background would readily accept Gabriel Kaufmann-Kohler's proposition that aside from procedural issues perhaps, one can see no precedential value or self-standing rule creation in commercial arbitration awards. Commercial arbitration awards are generally the result of private hearings, they're not published, and they cannot on any view therefore serve as law for an entire national community, as Michael Reisman points out. And he cites a statement by Justice Alito which had caused a certain amount of controversy in the Stolt-Nielsen case, but he does it with approval, and when you see the context in which he makes the point, it really does begin to make a lot of sense, with the greatest respect to Mr. Justice Alito. The panel, said Alito, that's the International Commercial Arbitration Panel, proceeded as if it had the authority of a common law court to develop what it viewed as the best rule to be applied in such a situation. And I think Justice Alito is absolutely right. That is an example of an international commercial arbitration tribunal trying to go too far and trying to produce law which goes beyond the four corners of the contract and the dispute with which it was involved. And as Michael Reisman points out, a truly case-specific approach would afford no attribution of precedential value to any prior decisions at all. So that's clearly not what we have in the field of investment treaty arbitration, where there is, as he's already said, and I agree with him, a need to look to see what has been done before to ensure a degree of consistency and cohesion. But what you're not doing is making law. And what you're also not doing is doing what Professor Reisman rather suggests the Lowen Tribunal did, and that is take a view of the wider context and then pull your punches. Because there was a real concern, apparently, that if the Lowen decision had gone a particular way, it might have precipitated a US withdrawal from NAFTA. Well, that's fairly heady stuff. But it doesn't seem to me that it's for a particular tribunal, however eminent, to have to take on board the possibility of something like that happening and leaving to one side the legitimate expectations of qualified investors who are seeking to bring about the observance of legal commitments by states which are meaningful and which they have every right to expect to be enforced. Now let me leave you with this, because I've gone on long enough, and it's perhaps slightly mischievous, but it seems to me that when it comes to interpreting the work of the policymakers, most of those engaged in that exercise are members of the self-same arbitration community, which those involved at the start of the process, i.e. the making of the policy, are very keen to avoid. And would it not make a great deal of sense to broaden perspectives of the policy drafters by letting them deal with the people who have to implement the results of what it is they put on paper? Thanks very much.
We invite questions. Don?
John, there's a lot of young people here who no doubt are hoping to enter careers as practitioners in the field of international arbitration. And you are in as good a position as anyone, no doubt, to answer this question, and that is, in investor-state arbitration, or will you probably be here. Roughly, how many more, as a factor, how many more commercial arbitrations are there going on in any given year than investor-state arbitrations and treaty arbitrations? Just a multiplier, 3, 5, 50?
Right. Let me deal with it this way. The totality of ongoing commercial arbitrations in the world is a number that no one knows, because there are institutional awards, institutional arbitrations, and they're also ad hoc. And there may be all sorts of ad hoc arbitrations going on we simply don't know about. Some arbitral institutions you need to take the figures with a pinch of salt, so let's put them to one side and say nothing more. But if you take the totality of the investor-state arbitration numbers to date, I think it's sitting at around 560, 570, it's that sort of order. In any given year, the ICC Court receives 750 to 800 new cases, and we're running a caseload of 1,500. So on the basis of one institution alone, and there are plenty of others with large numbers, AAA down the road is one of them. If you begin to put that into perspective, you begin to see that even though the number has exploded, I remember when Aaron Brochus was still at BCA and trying to deal with pre-exit. I think they had 4 cases by 1994, haven't they? From 1966 to 1994, they had 4 cases, and then suddenly there's an explosion. But it's still only in the 500s, I think. So that gives you a measure of the scale of the problem.
And where the opportunities for future work are.
Well, let me say this, and again, you're going to think me a real Cassandra, but I go to the Wismut in Vienna before Easter most years, and find myself surrounded by 2,000 or so kids whose aim in life is to become lawyers qualified and eventually practicing in international work in the broader sense, but what they really mean is international disputes work. And the sad fact is that you know very well that there's probably around 200 to 300 jobs going anywhere in the world with that degree of specialization. So the starting point is, for what it's worth, if you want some homespun advice, it's qualify in your national jurisdiction and qualify well, get a grounding in national practice, and then when you've done that, in a sense, forget everything you've learned and applied for the last few years and go and become an international lawyer. It's quite a transition, and one of the bugbears for an international arbitrator, be it investor state or indeed in commercial arbitration, just looking at it as an arbitrator, is that you spend the first half of the first hearing trying to educate, sometimes not altogether successfully, counsel from the UK who behaves like a barrister in front of a High Court judge, and counsel from New York who thinks he's screaming at another counsel from New York. And you put the rules in front of them and tell them that we're not playing that game, and they say yes, sir, we're not playing that game. Within 5 minutes they are again. So there's a huge cultural issue. That's far from what we're talking about here.
Last week, Ms. Jouvin-Brett from Paris spoke about investor-state arbitration. And she said that it was important to constantly reform and be proactive about the laws. And regarding NAFTA, do you think that this could be helpful even in state-state negotiations, to pave the way in a way
So what is it she's seeking to reform?
Well, just the way things are done or whatever.
So we're talking procedure now rather than the...
I guess so, yeah.
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 She said it was basically, it was a loose system, it wasn't really a system, so it's an ongoing
Well,
process.
in a way...
She calls it a lack of a system, actually, not to reform the system, the lack of it.
No, I think one has again to be very careful because too much prescription causes more problems than too little.
Yeah.
And it's one of the reasons why the ICC commercial rules are as expansive as they are, because they've always been expansive in their drafting, and it enables people to say, well, within that rule I can do a certain amount as an arbitrator, but the parties can adapt them in a particular way. When you're dealing with states, there's all the more need to ensure that you don't do anything which is too prescriptive. You look at the way the present arbitration rules are written for ICSID, they are quite expansive. And that's the result of very careful negotiation at a very serious level. If you talk to Meg Kinnear, she will tell you that one of the biggest problems she faces is actually having to take the deep breath and saying, do we now revise the rules? And there are things that do need revision. And I think most people these days would say it is absurd that if there is a challenge to an arbitrator under the ICSID system, then the other two members of the tribunal have to determine the challenge. That creates the most extraordinary tensions. And only if it's only occasionally does it go up to the president. So there's scope to change, but getting that to change it's like moving a supertanker. It takes a long, long time. There's an awful lot of people to ask about it. And even more so if you're dealing with treaties, because if it's a treaty between two countries, that's relatively easy. You've got two governments to persuade. If you're trying to redo the model law, then you've got to get everybody on. So it's an aspiration, and I think you do much better actually taking what's there and then trying to adapt it. People keep saying, well, it's time we rewrote the New York Convention. Well, not in my lifetime, I suspect, is the answer to that. We're now.
So you said that you see a role in investment arbitration for the ICC as opposed to ICSID, for example. But you also mentioned that a lot of the same arbitrators who are arbitrating in commercial disputes also arbitrate in investment disputes, and also, like for example, in PCA cases. So don't you think it would be more efficient to have, for example, the PCA deal with investment disputes and the ICC with commercial disputes in terms of, from what I know, the PCA has the state recognition by being an international organization that is driven by states. How do you see the role of the ICC in that?
Well, the PCA does have a particularly privileged position because it is regarded by states as it is one of their creations basically, and it's fully accredited diplomatically and all the rest of it. And it has a very important role to play. It quite often fulfills the role of nothing more than an administrator of these cases, and does it extremely well. I don't think that necessarily the right approach is to limit the field too far. There's a number of countries for which ICSID is complete no-go. There are others who will say, well, actually, we don't really want to go to the PCA either because we don't really understand it, and effectively it's nothing more, nothing less than another arm of the UN, so we're not wildly happy about that. We want some real depth and experience here. Now that's being unfair to Hugo Stiglitz and his team at the PCA, because they A, they're very competent, and B, they can get on board some very good arbitrators very quickly. But I think there's a sense that traditionally, for once I'll play perception to my advantage, that there is a perception that its tribunals tend to be heavily dominated by public international lawyers. And to that extent it's a little subset of arbitration specialists within already a specialised world. And there is simply sometimes a lack of commercial appreciation.
So I'm very interested in what you were saying about the arbitrator's approach to past cases and what the appropriate approach to past cases was. I really appreciate that the Saipem logic is quite extreme about there being a duty to look to and potentially even rely on past cases because they are past cases, not on the basis of their reasoning, but as a sort of pseudo precedent, and that's a problem. But as you indicated, and Reisman agrees, you can't just go completely the other way. There is a big problem with public investment awards of going completely the other way. And so then the question arises how you actually would see arbitrators appropriately dealing with the question of how we deal with past cases. Is there any kind of duty involved, a duty to look, a duty to engage with the reasoning at least? I mean, it becomes very murky.
Well, there is a duty to look, no doubt about that. But I think the key point in the Reisman analysis is that you start on the basis that your determination is relevant to this case and this treaty. And you start with the Vienna Convention, you look to see what the treaty says, and then you begin to see whether you will come up with a result which is consistent with the requirements of the treaty, requirements of the facts of the case, and is broadly within the framework of a consistent line of reasoning going back. So it's got to be something pretty extraordinary to turn on its head a line of cases which go one way on fair and equitable treatment, for example, or on expropriation. And that's not altogether surprising, because most tribunals are rational, most parties are well represented when they appear at that sort of level, and it would be very odd indeed if suddenly a decision were taken which would cart horses through an entire previous line. But that doesn't give them precedential value. And what I think Michael Reisman's complaining about is this sort of, well, I'm not going to say much less polite called mission creep, where tribunals say, well, not only can we look at what's gone before, but actually we ought to be saying something here to stop states doing this sort of thing. Yeah, and then you have a problem, because that's what seems a modicum of the wider awareness. Well, that's when it's positive. You get the low-end situation going the other way, when you see a tribunal saying, well, actually, you better not. So.
Some of the recent scholarship that we have coming out, particularly by the empirical sort of lawyers, suggests that the outcome in an investment state decision depends largely on the on the predominant background of the arbitrator.
Right.
And therefore the same case can be decided differently based on whether the arbitrator was either with a heavy commercial background or a public international background, or maybe a human rights background. Now my question therefore is this genuinely a problem in your experience? Particularly in the light of, a lot of notions that give tribunals a fair amount of latitude, what discretion do we allow to the state, how much latitude, how much margin of appreciation.
This is probably the wrong week to ask an English lawyer what he thinks of human rights lawyers after the decision of the Court of Appeal yesterday.
Yeah.
But on a more serious point, I think I don't know any commercial arbitrator who's gone into this work thinking it's simply a matter of picking up the bag from that side of the table and moving it over here and saying, well, I wear a different hat now, but I apply exactly the same standards. And inevitably, you learn very quickly that there are differences. And so I don't think, in a sense, it matters too much whether one's coming at this from a commercial background or from a PIL background. What worries me about some of the PIL guys is that they are terribly limited. It's not that long ago when I was in The Hague doing something else at the Peace Palace and overheard three very eminent civil law, public international law professors complaining bitterly over their lunch. They were having to deal with a commercial case. On closer inquiry, it turned out to be an investor-state dispute. But they were seeing the whole thing as commercial. And there's obviously got to be a meeting of minds between the members of the tribunal. But I haven't yet met any real problem where the tribunals come at it from three such completely different approaches that there's no way one can reconcile the views that they form. But it was very satisfying to see the Court of Appeal telling Brussels to get lost. Right.
Well,
You're far too generous.
It's almost on time.
Yeah, it's perfect timing, actually. So thank you very much
That's all.
again.